Okay, good evening, class. We are now approaching the semifinals. Okay, and tonight we are going to make a special lecture on special laws because this is our coverage for the semifinals. We will talk about the IPO, patent, etc. Okay, special law. But first of all, I'd like to, as usual, I'd like to acknowledge the following researchers to make this PowerPoint presentation possible. James Clifford Bonessa, Angelo Busio, Sara Kagata, Charmaine Angel B. Canonego, Mary Ann Caday, Kenzo Mark Boron, and Joseph Bintoso. Okay, as usual, we have to deliver a pre-test or post-test examinations on this first PowerPoint presentation for the semifinals. Okay, what are these questions for the pre-test and post-test? Number 1, what is an intellectual property office? Number 2, give at least 2 functions of IPO. Number 3, what is a copyright? Number 4, who are the persons that acquire ownership by intellectual creation? Number 5, what are the 2 copyrightable objects? Number 6, what is patentable invention? Number 7, how many years is the term of the patent? Number 8, what are the purposes of patent law? Number 9, what is literal infringement? How is literal infringement determined? And you will also learn what is doctrine of equivalence. Okay, let's go to questions and answer. Number 1, what is an intellectual property office? Answer, an intellectual property office is the body that administers the policies sought to be implemented under the IPC. Question number 2, give at least 2 functions of IPO. Answer, the following are the functions of IPO. A, examine applications for grant of letters, patent of inventions, and register utility models and industrial designs. B, examine applications for the registration of marks, geographic indications, and integrated circuit. Number 3, what is a copyright? Answer, a copyright is the right over literary and artistic works which are original intellectual creations in the literary and artistic domain protected from the moment of creation. Number 4, who are the persons that can acquire ownership by intellectual creation? Answer, the person that acquires ownership by intellectual creation are the following. A, with regards to his literary, dramatic, history, author, all legal, philosophical, scientific, or other works. The composer as to his musical composition. The painter, sculptor, or other artist with respect to the product of his art. And the scientist or technologist or any other person with regards to his discovery or invention. Number 5 question. What are the 2 copyrightable objects? Answer, the 2 copyrightable objects are 1, literary and artistic works, and 2, derivative works. Number 6, what is a patentable invention? Answer, a patentable invention refers to any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. Number 7 question, how many years is the term of the patent? Answer, the term of the patent is 20 years from the filing of the application. What are the purposes of patent law? Answer, the purpose of patent law are the following. 1, to seek to foster and reward invention. Number 2, to promote disclosures of inventions, to stimulate further innovation, and to permit the public to practice the invention once the patent expires. Number 3, the stringent requirement for patent protection seek to ensure that ideas in the public domain remains there for the free use of the public. Number 9, how is literal infringement determined? Answer, there is literal infringement, the defendant is liable. What is doctrine of equivalence? The doctrine of equivalence provides that an infringement also takes place when a device appropriates a prior invention by incorporating its innovative concept. Now let us discuss, because questions and answers which might be explanatory may be reinforced during the discussion. I hope you can bear with me. Okay. Let us talk about intellectual property. It is a state policy that the state recognizes that an effective intellectual and industrial property system is one vital to the development of domestic and creative activity. And it facilitates the transfer of technology, attracts foreign investment, and ensures market for our product. In other words, it is the policy of the state that he recognizes the effective industrial and intellectual property system of its citizens, because the state believes that intellectual property is vital to the development of domestic and creative activity, and intellectual property also facilitates the transfer of technology and also attracts foreign investment and ensures market for our products, because it's a property and subject to selling, and you can market out of your intellectual creation. What else? The state shall also recognize that the use of intellectual property bears a social function. In other words, it is a recognition in our law, under our constitution, that intellectual property is an imprimatur and it bears function or marks in our social function, our activity. What else? Intellectual property is also streamline administrative procedures. It concerns intellectual property, liberalize registration of transfer of technology, and enhance the enforcement of intellectual property rights. This is one of the policy of the state. What else? Section 13 of the Article 14 of the Constitution also provides that the state shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such period as may be provided. Why is it so that under Section 13 of the Article 14 of the Constitution, the state protects the exclusive rights of scientists? It is so because our law, the state, recognizes that you can make property out of your intellectual creation. That one of the aspects of property is an intellectual creation that must be protected. We have to honor the scientists, investors, artists, etc., or other gifted citizens, because they are helpers in order to move on with our society. So that we have to understand that. What else? Treaties are part of our laws, hence various provisions of treaties are incorporated in the IPC. Why is it that we're talking about treaties? It is so because other nations, other citizens of other nations also have their own intellectual creation from their citizens. Now, if they wanted to register, for example, how do they treat, for example, a Filipino citizen who is wanting to register his property outside the Philippines? And how do we treat also those foreigners in outside the Philippine territory who are doing some intellectual creations. What is our policy there? So there is a policy there that's being invented by our government or the state in order that intellectual property is given high priority or high importance. Okay. Geographic indications. Geographic indication is indication or are indications which identify a good as originating in the territory or a region or locality in that territory where a given quality, reputation, or other characteristics of good is essentially attributable to its original or geographical origin. It's found in section 6 or section 3, article 2021. Now, what does it mean? For example, Lacoste. Where does it belong? Where does it originate? What country? For example, Tommy Hilfiger as a brand or Nike. It identifies a country. Probably in United States, franchised by China, etc., and distributed here. But geographical locations identifies a product, for example. Let us convert our discussion here in the Philippines. For example, as a product, let us talk about our intellectual creation, our bayan. It's also part of the intellectual creation. The secret of making a calamay, for example, in Bohol. When you eat calamay, there is always that thinking that this belongs to the certain region in the country. For example, here in Butuan City, if you eat palagsing, for example, the ingredient, the system on how it is being cooked is identified to the territory where we are living, right? That's why geographic indications are also important in the study of intellectual property. Now, protection of information is disclosed. No? Natural and legal persons shall have the possibility of preventing information lawfully within their control from being disclosed to, acquired by, or used by others without their consent in the manner contrary to honest commercial practices, breach of contract, breach of confidence, fraudulent inducement, so long as the information goes on and on. Okay? Is it okay that I will not disclose to you how or the marketing strategy of a brand or commercial practices? That is still also protected in the intellectual property, in this intellectual property law. Secret is in the sense that it is, you see, information with regards to your intellectual creation is secret in the sense that it is not as a body or in the precise configuration and assembly of its components generally known among or readily accessible to person within the circles that normally deal with the kind of information in question. In other words, if you have the marketing secret, or you cannot just divulge it because you are allowed to keep it, no? And then you are protected from your commercial value because it's a secret that has been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. Secrecy as to the matter of your trade secret, of your trade practices, etc., is being acknowledged under the intellectual property law. Intellectual property law consists of what? Copyright and related rights. 2 or B, trademarks and service marks. C, patent. D, geographic indications. E, layout designs or topographies of integrated circuits. F, protection of undisclosed information and industrial designs. Now, number 3, international law-related provisions. As I've said, other countries also have their own policy on intellectual creation for its citizens, just like us. So that is why international law or the international community have devised a policy so that we can come together into an agreement. One of the policy under international law is the doctrine of reciprocity. What is that? It is a doctrine where any person who is national or who is domiciled or has real and effective industrial establishment in a country in which is a party to a convention. In other words, if one country or a person living in the country where it is member of that organization or the convention, treaty or any agreement relating to intellectual property rights or the repression of unfair competition to which the Philippines is also a party. So we can deal with the registration to countries which only has its policy similar to us. And it extends the reciprocal rights to nationals of the Philippines by law and shall be entitled to benefits to the extent necessary to give effect to any provisions of such convention, treaty, or reciprocal laws, in addition to the rights to which any owner of an intellectual property rights is otherwise entitled by this act. National treatment. Each member of the World Trade Organization Agreement on trade-related aspects of intellectual property rights, or TRIPS for short, shall accord to nationals or the other members no less favorable than that it accords its own nationals with regard to the protection of intellectual property. Okay. Trade-related aspect on international property rights, that is Article 3 in the World Trade Organization's agreement. What does it mean? That, for example, if a German individual was able to make an intellectual creation, wanting to register it, they can be entitled with same right like a Filipino if in their country they also accord the same protection with the Filipinos. That is how we explain reciprocity. Now, most favored nation treatment. What is that? With regards to the protection of intellectual property, any advantage, favor, privilege, or immunity granted by a member to the nationals or any other country shall be accorded immediately and unconditionally to the nationals of all other members of the World Trade Organization, TRIPS, that is found on Article 4 of the same law. Trade-related aspects of intellectual property rights, or TRIPS. So, those who a country has a reciprocal rights or reciprocal treatment from the nations or the country in which they are registering, they can have the most favored treatment, for favored nation treatment. Intellectual Property Office. What is it? It is the body that administers the policies sought to be implemented under the Intellectual Property Office. What are the functions of the IPO, so to speak? 1. Examine applications for grant of letters, patent, inventions, and register utility models and industrial designs. What else? It examines applications for the registration of marks, geographic indications, integrated circuits, register technology transfer arrangement, and settle disputes involving technology transfer payments. D. Promote the patent information as a tool for technology development. E. Publish regularly in its own publication the patents, marks, utility models, and industrial designs issued and approved, and the technology transfer arrangement registered. What else? What are other functions of the IPO? Administratively adjudicate contested proceedings affecting intellectual property rights and coordinate with other government agencies and the private sector to strengthen the protection of intellectual property rights in the country. Now, copyright. Let's discuss about what a copyright is. Copyright is a right over literary and artistic works which are original intellectual creations in the literary and artistic domain protected by the moment from the moment of creation of the author. Collective work. It is a work which has been created by two or more natural persons at the initiative and under the direction of another, with the understanding that it will be disclosed by the latter under his own name and that contributing natural persons will not be identified. An intellectual creation is one of the modes of acquiring ownership under the Civil Code. The following persons acquire ownership by intellectual creation. One, with regard to his literary, dramatic, historic, author, all legal, philosophical, scientific, or other works. Who are those persons? Said the author, the composer as to his musical composition, the painter, sculptor, or other artist with respect to the product of his art, the scientist or technologist or any other person with regards to his discovery or invention. Letters and other private communications in writing are owned by the person to whom they are addressed and delivered, but they cannot be published to the writer or his ears. When rights are copyrighted are confirmed. Rights over copyrights are conferred from the moment of creation, which is found in section 172 sa paragraph 1 of the IPC. The work is deemed created if something original is expressed in a manner, is affixed in a manner. 1987. Who owns the copyright? The creator. Creator, his heirs, or assigns who owns the copyright. Who else? Joint creation. Co-authors shall be original owners of the copyright, and in the absence of agreement, their rights shall be governed by the rules of co-ownership. Commission work. In the case of commission work, the person commissioning owns the work. Ownership of right remains with the creator unless there is a written stipulation to the contrary. What about audiovisual work? The producer for purposes of exhibition, for all other purposes, the producer, the author of the scenario, the composer, the film director, the photographic director, and the author of the work of the work are the owners. Again, who owns the copyright? In one creator, the creator, his heirs assigns who will own the copyright. When it's a joint creation, the co-authors. When it is commissioned work, the person commissioning the work. And when it's audiovisual work, the producer or purposes of exhibition. Okay. Now, let us talk about the jurisdiction of copyright. What is the jurisdiction of copyright? As far as literary, artistic works and derivative works, during the lifetime of the creator and for 50 years after his death. Okay. What else? As far as joint creation, the economic rights shall be protected during the life of the last surviving author and for 50 years after the death of the last surviving author. Acronymous or a pseudonym work till the end of 50 years following the date of their first publication. The 50-year duration commences from January 1 following the date of publication. What about the work of applied art? It must be 25 years from the date of making. Now, duration of the copyright continue. What about photographic works? 50 years from the publication of the work or from making it unpublished. The same term is given to audiovisual produced by photography or analogous process. What about broadcast? It must be 20 years from the date of broadcast. Okay. Let us ask, what are copyrightable objects? On the copyrightable objects, we have literary and artistic works, and B, derivative works. A, any idea, procedure, system, method, or operation, concept, principle, discovery, or mere data explained as such, even if they are illustrated or embodied in a work. What else? News of the day and other miscellaneous facts having the character of mere items of press information. C, any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. What else? Any work of the government of the Philippines, however, prior approval of the government agency or office wherein the work is created shall be necessary for exploitation of such work for profit. Such agency or office may, among other things, impose as a condition the payment of royalties. No prior approval or condition shall be required for the use of, for any purpose, of statutes, rules, and regulations, and speeches, lectures, sermons, addresses, and dissertations, pronounced, read, or rendered in court of justice before administrative agencies, in deliberative assemblies, and meetings of public character. What else? The trade name and container of the medicated cream is the proper subject of trademark. Hence, copyright and patent registration of the name and container would not guarantee the registrant the right to the exclusive use of the same, not being the proper subjects thereof. What else? Copyright gives no exclusive right to the art disclosed, unlike patents, but only to the expression. Copyright registration over a drawing or pictorial illustration which depicts light boxes or box-type electrical devices protects the drawing but not the light box depicted therein. Okay. So these are the unprotected works. Let's talk about moral rights. It requires, number one, that the author of the work shall be attributed to him in a prominent way on the copies and with the public use of the work. Number two, to make any alteration of his work prior to or to withhold it from publication. Number three, object to any distortion, mutilation, or other modification of or other derogatory action in relation to his work which would be prejudicial to his honor or reputation. And number four, restrain the use of his name with respect to any work not of his own creation or in a distorted version of his work. Let us discuss a little about intellectual property code. One, right to publish granted by the author, his heirs, or his assigns. That is the basic on the that is very basic provision on the intellectual property code. What else? The publisher shall have copyright consisting merely of the right of reproduction of the typographical arrangement of the published edition of the work. Number three, if submitted to newspaper, magazine, and the like, the right to publish once material sent by the writer, a photographer, an artist, a periodical or newspaper publisher, but such writer or artist retains his copyright on the piece. Now let us talk about performers' rights. As regards to their performance, the right of authorizing, one, broadcasting and other communication to the public of their performance, and two, the fixation of their unfixed performance. B, the right of authorizing the direct or indirect reproduction of their performance fixed in sound recordings or audiovisual works or fixations in any manner or form. C. The right of authorizing the first public distribution of the original and copies of the performance fixed in sound recording or in the audiovisual works, or fixation through sale or rental of other forms of transfer of ownership. D. The right of authorizing the commercial rental to the public of the original and copies of the performances fixed in sound recordings or audiovisual works of fixation even after distribution of them by or pursuant to the authorization of the performer. Now, continuation of the performer's right. E. The public of their performance fixed in sound the right of authorizing the making available to by wire or wireless means in such a way that recording or audiovisual works or members of the public may access them from place and time individually chosen by them. F. Moral rights performers. The right to claim to be identified as the performer omission is dictated by the manner of the use of the performance and to object to any distortion, mutilation, or other modification of his performance that would be prejudicial to his reputation. These are the performer's rights as far as the performance is concerned. Okay. The following are the acts which does not infringe a copyright. A. Recitation of performance of a work made accessible to the public, which is 1. Privately done, 2. Free of charge, 3. Strictly for charitable or religious institution, and B. Making of quotations from a published work incompatible with fair use, and then extent is justified by the purpose. Example, the source and name of the author appearing in work must be mentioned. 2006 bar, it appeared there. Reproduction or communication to the public by mass media of articles on current political, social, economic, scientific, or religious topic, lectures, address, and other works delivered in public. What else? For information purposes, not expressly reserved, and those that are source is already indicated. Now, reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events by means of photography, cinematography, or broadcasting to the extent necessary for the purpose is one of the acts that does not infringe copyright. What else? Inclusion of a work in a publication, broadcast, or other communication to the public. Sound recording or film if made by way of illustration for teaching purposes. That's what we are doing right now. Compatible with fair use, and the source of the name and the author appearing on a work must be mentioned. F. Recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of schools, universities, and educational institutions. Such recording must be deleted with reasonable period. In such recording may not be made from audiovisual works which are part of general cinema repertoire or feature films except for brief excerpts of the work. G. Making of ephemeral recordings by broadcasting organizations. B. By means of its own facilities for use of its own broadcast are acts that does not infringe copyright. H. Use made by work over under the direction and control of government, national library, educational, scientific, or professional institution for public interest compatible with fair use. What else? Public performance or the communication to the public of a work in a place where no admission fee is charged by a club or institution for charitable or educational purpose only, and the aim is not profit-making. J. Public display of the original or a copy of the work not made by means of a film, slide, television image, or otherwise on screen, or by means of any other device or process. Either the work has been published, sold, given away, or transferred to any person by the author or his successors entitled. K. Any use made of a work for the purpose of any judicial proceedings or for the giving of professional advice by a legal practitioner. What else? Single copy reproduction of a published work by a natural person exclusively for research, private study, even without authorization. What else? Reproduction by non-profit libraries of one, a fragile, two, isolated articles in composite works, preserve or replace copy that is lost, destroyed, or rendered non-usable. 3. Brief portions of published work. 4. To works, one backup copy of computer program. What is a doctrine of fair use? The doctrine of fair use is meant that fair use is a privilege to use the copyrighted material in a reasonable manner without the consent of a copyright owner or sa copying the theme or ideas rather than their expression. Fair news reporting, teaching, including multiple copies use of a copyrighted work for criticism, comment, for classroom use, scholarship research, and similar purpose is not an infringement of a copyright. This is what we are doing right now because I am giving to you the law so that you will learn for educational purposes. This does not infringe copyright. Factors to consider to determine whether use is fair or not fair. 1. What is the purpose and the character of the use? 2. What is the nature of the copyrighted work? 3. Amount and substantiality of the portions used and effect of the use upon the potential market of the copyrighted work. Then let's talk about importation of personal purposes. The importation of a copy of a work by an individual for his personal purposes shall be permitted without the authorization of the author of or other owner of a copyright. Let us talk about infringement. How made? When there is piracy or substantial reproduction, there is infringement. If so much is taken that the value of the original work is substantially diminished or the labors of the original author are substantially and to the injurious extent appropriated by another. Infringement, therefore, is more of a property, more of a monetary value. What else? A person infringes a right protected under this act when 1. Directly commits an infringement, benefits from infringing activity of another person who commits infringement if the person benefiting has been given notice of the infringing activity and has the right and ability to control the activities of other person, with knowledge of infringing activities, induces, causes, or materially contributes to the infringing conduct of another. Now, what are the remedies? For example, if you are a victim of infringement, 1. Injunction to prevent the infringement. You go to the court, file a case, and ask the judge to stop. You enjoin the user to stop doing it. What else? You file a case for damages, for which should be filed within 4 years. Damages are assessed on the basis of the proof alleged by the plaintiff of sales made by the defendant on the infringing work minus whatever cost the defendant may be able to prove and appreciated by the court. The third remedy, criminal case. The infringer also exposes himself to criminal liability wherein the law prescribes penalties of imprisonment and fines, including the subsidiary imprisonment in case of insolvency. Retransmission. Note, this is a corporation that provides satellite television service is not infringing the broadcasting and copyright of the television provider, merely carries or simultaneously retransmit the signals unaltered from pursuant to the must carry rule station if the satellite television provider merely imposes by the NTC. Under the must carry rule, take note of that, the NTC requires satellite and cable television provider to carry all local stations, while the roam The NTC requires satellite and cable television convention gives back broadcasting organization of its broadcast. This protection does not extend the right to authorize or prohibit rebroadcasting to satellite or cable transmission. Now, technological measures. Circumvention of technological measures does not by itself constitute infringement. Take note, however, such circumvention may increase the penalty for infringement of a copyright provided that such infringement is first established. You have to have a basis. You lay down that there is infringement before you can proceed. And then, technological measure means any technology, device, or component that in the normal course of its operation restricts act in respect of a work, performance, or sound recording which are not authorized by the authors, performance, or producers of sound recording concerned or permitted by law. A lessor or owner of the place where the infringement of copyright may be committed may be held liable only if it can be established that he or she, 1, benefited from infringing the activity, 2, has been given notice of the infringing activity and a grace period to act the same. Number 3, he has the right ability to control the activities of the person who is doing the infringement. Now, format for the blind. Reproduction or distribution of published articles or materials in a specialized format but with the indication of the original owner and the date of the original publication exclusively for the use of the blind, visual and reading impaired persons or a non-profit basis shall not constitute infringement. When we talk about this, we are reminded of the Braille, the Braille system. Now, patents. Patentable inventions refer to any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. What are the requisites of a patent? It must be a technical solution of a problem in any field of human activity. It must be novel invention, and it is industrially applicable. Now, definition. What do you mean by novel? Which does not part of a prior art. Something which is new. We say in novel, meaning something which is new. Something which has not been explored before. That is a novelty. Prior art. Prior art is that which has been made available to the public anywhere in the world before the filing date or the priority date of application. Prior art means when there is already that kind of art and you are applying now. There are already inventions like that. That which form part of the application, whether for patent, utility model, or industrial design, which is effective in the field. Now, definition, let's talk about inventive step. What is that? An invention that involves an inventive step, if having regard to prior art, it is not obvious to a person skilled to the art. That is called an inventive step. When it's not obvious to a person skilled in the art, at the time of the filing date or priority date of the application claiming the invention. What else? It's a mere discovery of a new form or new property of a known substance which does not result in the enhancement of the known efficacy of that substance. Number 2, it's a mere use of a known process unless such known process results in a new product that employs at least one new reactant. Now, person skilled in the art and industrial applicability. What is that? It is an invention that can be produced and used in any industry. Person skilled in the art, those that can, it's very easy to understand that. No? And what are the purposes of a patent law? The patent law has threefold purpose. 1, patent law seeks to foster and reward invention. 2, it promotes disclosures of inventions to stimulate further innovation and to permit the public to practice the invention once the patent expires. 3, the stringent requirements for patent protection seek to ensure that ideas in the public domain remain there for free use of the public. Now, what are the classes of patentable inventions? 1. Useful machines, product, process, improvement, microorganisms, and non-biological and microbiological processes. What are non-patentable inventions? Take note of this. Discovery, scientific theories, mathematical method. What else? Schemes, rules, and methods of performing mental acts, playing games, or doing business and programs for computer. These are not patentable innovation. Methods for treatment of human body or animal body, for surgery or therapy, and diagnostic methods practiced on the human or animal body. D. Plant varieties of animal breeds of essentially biological process for the production of plants or animals. E. Aesthetic creations. F. Anything which is contrary to public order or morality. And drugs and medicines. Persons entitled to a right. 1. A. The right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons have jointly made an invention, the right to a patent shall belong to them jointly. Let us talk about the first to file rule. If two or more persons have made the invention separately and independently of each other, the right to the patent shall belong to the first person who first filed an application for such invention. And then, persons that are entitled to a right. A. The right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons have jointly made an invention, the right of the patent shall belong to them jointly. And we also discussed already that right to patent rule. Now, what are the limitations of patent rights? The following acts are not prohibited, or the limitation. 1. Owner's consent. 2. Parallel importation. 3. Non-commercial. 4. Experimental use only. 5. Drugs and medicines. 6. Medicine and individual preparation. 7. Patent exhaustion. Now, prejudicial disclosure. Whatever right one has to the invention covered by the patent arises alone from the application date. Thus, if the inventor voluntarily discloses it, such as by offering it for sale, the world is free to copy and use it with impunity. Ideas once disclosed to the public without the protection of valid patent are subject to appropriation without significant restraint. Non-prejudicial disclosure. Any disclosure of the invention made within 12 months from the filing date does not prejudice the application if the disclosure is made by inventor himself, patent office, and the third party. Now, what is the term of patent? The term of patent is 20 years from the filing date of application. Infringement. Infringement is the making, using, offering for sale, selling, or importing a patented product or a product obtained directly or indirectly from a patented process, or the use of a patented process without the authorization of a patentee. In case of infringement, the patentee shall have the exclusive right to 1. Restrain the unauthorized entity for making, using, offering for sale, selling, or importing. 2. To prevent or prohibit the use of the process or from selling, offering for sale, or importing product obtained from the process. 3. Recover damages in a civil action for infringement which can be equivalent to royalty or an amount that does not exceed 3 times the amount of actual damages. And 4. And to ask to the court to order that the infringing products or goods be paid. Now, steps in determining the presence of infringement. Determine if there is literal infringement. If there is literal infringement, the defendant is liable. If there is no literal infringement, then the doctrine of equivalence should be applied. What do you understand by literal infringement? It is called exactness rule. The item is being sold, made, or used conforms exactly to the patent claim of another. Exactly. That is exactness rule. Additional rule. One makes, uses, or sells an item that has all the elements of the patent claim of another plus other elements. That is additional rule. What do you understand by the doctrine of equivalence? The doctrine of equivalence provides that an infringement also takes place when a device appropriates a prior invention by incorporating its innovative concept. The principle or mode of operation must be the same or substantially the same. The patentee having the burden to show that all three components of such equivalency test are met. 1. The doctrine of equivalence cannot be applied when the infringing invention is clearly beyond what is written in the claim. 2. When the language of a patentee's claim is clear and distinct, the patentee is bound thereby and may not claim anything beyond them. And so are the courts bound such that they may not add to or detract from the claim matters not expressed or necessarily implied. Compulsory licensing. If the patented invention is not being worked in the Philippines on a commercial scale, although capable of being worked without satisfactory reason, provided that the importation of the patented article shall constitute working or using the patent. 6. Where the demand for patented drugs and medicines is not being met, an adequate extent of a reasonable terms is determined by the Secretary of Department of Health. In whose favor, compulsory licensing should be granted to any person who has shown his capability to exploit the invention. Time when the application for compulsory licenses cannot be applied before the expiration of a period of 4 years from the date of filing and the application of 3 years from the date of the patent, whichever period expires last. Now, requirement to obtain a license on reasonable commercial terms. Compulsory licensing means it's a license issued by the Director General of the Intellectual Property Office to exploit a patented invention without the permission of the patent holder, either by manufacture or through parallel importation. What are the grounds? 1. You can do that only, 1, when there is a national emergency or other circumstances of extreme urgency. For example, that COVID. 2. Where the public interest, in particular national security, nutrition, health, or the development of other vital sectors of the national economy as determined by the appropriate agency of the government so requires. 3. Where the judicial or administrative body has determined that the manner of exploitation by the owner of the patent or his licensee is anti-competitive. 4. In case of public commercial use of the patent by the patentee without reason. And with that, we have ended our lecture for the first PowerPoint presentation for the semi-final coverage. Class, I hope you have studied these lessons because it will come out in our semi-final exam. I understand that this subject is quite boring, but just the same, it is our obligation to study. Okay? So thank you and good evening.